Thanks for jumping on, everybody. I know we're still getting some people situated, but I wanted to at least introduce and give Andrea enough time to share what she has today. So thanks for jumping on. My name is Shannon. I am one of the managing brokers for Best Choice Realty. And I've got Andrea Lauritzen here from Smith Alling, who is going to be going over trust. Before I turn it over to her, I wanted to kind of do a little housekeeping, I would say, just as we kind of get situated here. We'll open it up for questions at the end. If you've got something that's like clarifying, throw it in the chat and I will be happy to ask the question for you. If you're a little bit shy, I'll do the same thing there too. Go ahead and use the chat function, but we will open it up for mics at the end. So if you wanted to ask Andrea directly, you're welcome to. And perfect. Well, thank you for joining us, Andrea. Thanks for jumping on. She is one of our favorite estate planning attorneys, and she's actually working on my own personal estate. She's done Rochelle's in the past, helped us with several business entities, all sorts of stuff over the years. So we're keeping her busy. So thanks for jumping on, Andrea. I'll let you kind of take it from here.
Yeah, thank you, Shannon. Thank you, everybody, for joining. I really always like going over these. I think we did a power hour a few years ago, and this one is specific to Trust 101. I know there are a lot of people that are specifically here with Best Choice Realty, so I put a couple slides that speak specifically to agents, and then I also have a few people that are here. So this is intended to be information that could be helpful for anybody, whether you're helping a client of your own or you're interested in for your own estate planning needs. Hopefully everybody finds something useful here. My plan for today is I want to establish what are the basics of estate planning, what a trust is, how it works, common types of trust, and for the agents in here, the intersection of trust and real estate transactions, and then considerations where when you want to choose a trust. And then I've got a case study. I find stories are the best way to sort of explain what I'm talking about. So I've got a case study that kind of breaks it down. And then some pitfalls of if somebody chooses a trust. A lot of people, want to avoid probate or think trusts are the only way to go. They're not necessarily. So I have broke it down in here about what, when you would choose it, when you would not. And then, like Shannon said, I've got time for questions and answers at the end. So people always ask me, well, what's the point in estate planning? Why do I care? A lot of times that come up, what I see is, what happens if somebody doesn't do an estate plan? It's confusing who's in charge, what's going on here. So estate planning, obviously, it clarifies who's in charge. It addresses family dynamics. What I've learned in my just line of practice in my own life, no family is normal. It's normal to not be normal. So family dynamics are a common issue that we want to make sure are addressed in your estate planning. It empowers people to direct their own lives, their own assets. Of course, there's asset protection, and then contingency planning. You never know what's going to happen in the future. When you're starting up an estate plan, a couple things to start up. It's not a one size fits all. You want to know, what are the assets we're trying to protect here? Do we have houses? Do we have companies? Do we have accounts? What are we doing here? And then how are they titled? Are they co-owned? Are they already in a trust? Were they inherited by a family member? Are they investments that you have with a friend or whomever? How is this actually titled? And then what do we already have in place? And who do we want the assets to go to? Is it going to be minors? Is it going to be people with special needs? Any special protections? Is it going to be a spouse? Is it a spouse, then children? Those are all the considerations to keep in mind. And then, of course, we can never forget about taxes. We can't escape those. And we also need to make sure we're looking at the whole picture of what's happening. And a lot of people, they'll update their estate plan, but they'll forget about their beneficiary accounts and that their beneficiary accounts have assets going to somebody else. The worst, well, it's not the worst, but a terrible story is when a gentleman, he named his girlfriend who he was with at the time. He started a job. They broke up. 25 years later, he's completely forgotten about all of that. He passes away. Guess who got that 401k? And so you want to make sure your beneficiary designations are considered. And then, of course, who should be in charge and under what authority that should happen. So I know a lot of you guys run into powers of attorney, you run into trust documents, and there's differences on what those mean and what they control. And I always like to consider, I do Medicaid planning as well. So if we're looking at protections for long-term care costs, if somebody's going to ultimately go into a nursing home or an adult family home, I like to take that into consideration as well. A lot of people don't know they already have an estate plan in place. So if you have not created your own powers of attorney, your own will, your own documents, that's okay. The state of Washington has an idea of what you might want. The problem that a lot of people have is Washington's not correct, right? So not everybody has the spouses who have the joint kids and everything goes, spouse to spouse and then to the joint kids. That's not what everybody has. And sometimes those kids are minors or they've got disabilities or whatever issue might come up. The other issue that comes up is if you've got later in life marriages, for example, if you do nothing and one passes away, everything goes to the surviving spouse, and then they can do what they want with it. They're not necessarily going to give it back to your kids, right? So those issues come up all the time. The other part of it is what happens if you end up not having capacity, right? You're in long-term care and you're not able to make your own decisions. Powers of attorney are the only real way to keep it outside of the court system. So if you don't have powers of attorney in place and you're not able to make your own decisions anymore, the court has to step in and there has to be a guardianship and it can get really complicated. And so that's where doing your estate planning, is important. The documents that I like to put in place are what everyone thinks about: your last will and testament, power of attorney, healthcare power of attorney, mental health advance directive. That one's important where we've got dementia and Alzheimer's are a lot more common. And then we've got, of course, your healthcare directive and a HIPAA form. These I put in place. If you have a trust or don't have a trust, I'm going to put these documents in place. They're still going to be relevant to you. The other part of it is going to be maybe a community property agreement. In Washington, we are a community property state, but you guys see it all the time as agents that just because somebody passes away, it doesn't mean their name was taken off title to that house. And so we can use things like a community property agreement when one spouse passes away, but there's still a surviving spouse to help avoid having to go through probate to remove names from titles for real estate, for example, or for accounts. A trust would be on top of these documents. And so this is the basics, but we're here to talk about trust documents. So when people, it's, well, what do we do? So a person passes away. Now what are we going to do? And it's the same questions. What are the assets? How are they titled? What documents are in place? So when you guys are working with somebody and this comes up, this is what you're asking. The other thing is who's in charge and under what authority. A lot of people think, oh, I have got the power of attorney, but if the person's passed away, that doesn't work, right? And then the other part of it is, okay, now what do we do? And this is going to apply the trust administration and the estate administration, the probate process. It's the same general process. It's just a matter of how do we get the power, right? So if we don't have a trust, then we do generally have to go through the probate process. If we have a trust, then the trust will just dictate what happens, but it's going to be the same. Number one, collect the assets. What do we have here? Number two, pay off the debts, address the taxes. Number three, distribute the assets. And it's always easier said as a high level picture than it is to actually do. And so when I'm talking collect the assets, a lot of times you're looking at, well, okay, we have a house. What are we going to do? Well, we can sell the house or we can transfer the house. And that's where, the time that it takes, people say, well, I hear it takes a long time. Well, sometimes what takes a long time is the person in charge is not ready to fix up the house or is not ready to sell the house. And that's what takes a long time. It's not necessarily the court process or whatever that might be. It's the person taking time. So now we're going to get into, well, what is a trust? How does it work? How does it operate? And I've gone back and forth of how do I describe a trust? And usually I keep saying the word trust every time I describe it. So I've tried to come up with a way that doesn't just keep repeating the word trust. It's a legal arrangement where a person, the trustor, transfers assets, so that can be house, that can be anything, any type of asset, to be managed by someone. And the person managing it is called the trustee, and it's on behalf of someone, and that's going to be your beneficiary. So if you really, really break it down, if Pat gives Sam $500 to hold for you, a trust has been created, right? Because somebody gave somebody an asset to hold for somebody. That's it. There doesn't need to be more than that. Obviously, we like there to be more than that because we want to be clear about, well, what are the rules here? What protections are in place? But it's as basic and as simple as somebody is holding something for someone. Common types of trusts, a lot of these are umbrella terms. People hear about testamentary trusts, revocable living trusts. That's the more common one that when people talk about, I have a trust, they're usually saying a revocable living trust or some sort of a break off from that type of trust. We have irrevocable trusts. Irrevocable is a blanket term. Special needs trust is a type of irrevocable trust. Testamentary trust is a type of irrevocable trust. There's children's trusts, credit shelter trusts. There's tons of different types of trusts that we use. What do they do? How do they work? The basics is they establish the management of your assets when you pass away, also while you're still alive. So that's what makes a trust different than a will. It can be in effect while you're actually still alive. It identifies who's in charge here. And that in a trust is going to be the trustee. That's the name of the person that's in charge is the trustee. In order to put one together, pretty basic requirements. You've got to be over 18. You do have to be alive and competent. I've got people who come to me and say, my mom passed away. I want to put her house in a trust for her. It's too late, but if you inherit the house, you can make a trust for yourself, but you can't do it after they've passed away. Whether or not you can change the terms of a trust depends if it's irrevocable or not. It depends on what the trust says. It's effective whenever it's created. So a testamentary trust is one that is going to be built within your will. And so that's why that one is not effective until you've actually passed away because your will does not come into effect till you've passed away. But generally, a trust is effective as soon as you create it and put the asset into the trust, the rules apply. They're a separate entity like an LLC or a corporation. They do not go through probate. It's a private process. It doesn't become public. And that's a lot of people like that about a trust. When the person, the trustor who created it, passes away, the assets, they continue to be owned by the trust. And so that's where, remember, you have to actually transfer the assets to the person they're supposed to go to, or maybe they stay in the trust. It depends on the rules of the trust. Only the assets that are actually owned by the trust get transferred based on the rules of the trust. And you guys probably see it a lot on your end for property titles, how to actually title real estate into the trust. It's the name of the trustee's name of the trust, date established. So here's an example. Pat and Sam as trustees of the Smith Family Trust. And the date established is always included because people create different trusts at different time of their lives. There could be another family out there called the Smith family. We want to know which one we're talking about. Considerations to think about when real estate is actually owned by a trust is who is in charge. It is the trustee that's in charge, not the power of attorney, not the personal representative. It's very likely that the person that named whoever they named chose their same favorite person to be the power of attorney and to be the personal representative, but you need to use the trust document to have the power. And the current trustee is not always the same as the person named on the vesting deed. Remember, to title the house into a trust, you're going to put Pat and Sam as trustees. Maybe Pat and Sam are in a nursing home now, and Sarah is their daughter who's acting as trustee. So maybe Sarah's the trustee now. So you need to look further than just on the deed of who's in charge. And the other tricky thing that comes up is the sale proceeds. have to actually go into the trust. And so not everybody creates an account owned by their trust at the time they create their trust. And so that's a hiccup I see a lot of times for realtors is they will get a house sold and everything is looking great, but then the client doesn't have an account owned by their trust. And so making sure they've got somewhere for the money to go once the sale closes is very important in making sure that the client doesn't experience a delay. The other part of it is if you see that you're selling property owned by a trust, it's helpful to find out, and I'll give an example later on, of maybe they put it in a trust on purpose, and if they're buying another property, does that new property need to also go into a trust? Is that part of their estate planning? Is that important to consider? And the other thing is you might find that there's a certificate of trust needed. All of this you're going to find out. Title will tell you what they want. As far as the trustee role, how it works, what their job is, they're named in the trust document itself as far as here's who's in charge and in what order. The authority for them to be the trustee is as soon as they accept the role and they assume that position. So it might be that somebody says, I'm trustee for myself. As soon as I'm not able to do it, then I've named persons 1, persons 2, persons 3 as my backups. Your backups are not in charge until they are, right? And so until the first one is no longer doing the job. They can come in as trustees while the person's still alive or after they pass away. It's whatever the person wants. And they do whatever the trust says. I've got, sometimes trustees, they think they have a better idea of what could have happened and how their parents or whoever could have done their estate planning. Just because they're the trustee, it doesn't mean they get to use their better ideas. They have to do whatever the document says. Even if they don't like the people that the parent liked, that's who gets the assets. That's what's happening. They're required to keep an accounting and keep the beneficiaries informed. They can't just do whatever they want and then not tell the people who are entitled to the money or the assets what's happening with the money or the house or whatever. In Washington, there's several reasons why somebody would want to use a trust. Washington is what's considered a probate-friendly state. That doesn't mean that everything should go through probate. There's reasons not to. And one of those is if you have out-of-state real estate. If you have anywhere that you have real estate, there has to be a probate done in every single one of those states, right? Because Washington probates only have jurisdiction over Washington land. So if somebody has real estate outside of Washington, then I'm typically telling them, let's put a trust together for you, and the trust will just own the property. That way, the trust doesn't die, right? The person passes away and the trust lives on. We avoid a probate out of Washington and in Washington. If you exceed the Washington estate tax limit, that's currently $3 million. If there's a need for continuity of ownership of assets, that one typically is going to come in if you think of a later in life marriage, for example. If you got a house, a husband, wife, or living in it, it's the wife's house. She had it before she ever met the guy. She's probably gonna want to create a trust, allow that trust to keep owning the house, and then the husband can keep living there. But when he passes away, then her trust will say, okay, now go ahead and give it to my kids, because it was my house to begin with. And then another issue is if you've got desires to provide for someone and control what happens after you pass away. So we call it the dead hand control. A lot of times people aren't ready to just hand their assets over to somebody, and maybe there's good reason for that. That's going to be if you have a minor, right? You're not going to just hand it over to a minor. You can't. If you have somebody with special needs or somebody who runs through money pretty quickly. And then if you want your estate plan to remain private, not everybody wants the world to know what they did with their assets. And when you pass away, your will does have to go through probate, and your will becomes a public record at that time. We sort of talked about this. If any of your beneficiaries are on government benefits, if you've got any minors or young adults, then you might want to do a trust. And then if you have any issues, if your beneficiaries are like to have issues with creditors, a divorce or bankruptcy, maybe you put it in a trust so that their inheritance does not get subject to their problems. Tax considerations, Washington's estate tax is at 3 million. Everything over that is taxed. There is a marital exemption, meaning if you give, everything to your spouse, then there's not a tax at that time. But if you don't have a surviving spouse, then that tax will apply. There's not portability in Washington. So what that means is if you have a married couple and they each have, if there's 6 million, they each, can have their 3 million. They can only actually each have their 3 million if you've properly planned. And you typically we use a trust to plan for this scenario. So a married couple can each have their full exemption. On the federal level, it's 15 million. Same thing, spouse to spouse, there's not a tax. And on the federal level, then where a married couple can kind of double up and they can use each other's full exemption, doesn't require as much planning on the federal level. There's always capital gains. You guys see it a lot when you are doing for houses. Obviously, if the house stays in the name of the person or stays in a trust for that person, they get all that equity can become capital gains tax free, and that's a good planning tool to keep as much assets in the family as possible. Real estate agent's role in estate planning, probates, and trusts. Your job is to spot the issues, ask the questions, educate the clients where you can, and connect them to an attorney or an accountant if needed. That's pretty much that's the best I see when realtors are able to really understand and identify. I notice a difference with my clients where the transaction can become really cumbersome if the realtor doesn't know, isn't familiar with the documents, and so doesn't know which ones are needed, and the client can be overwhelmed when they find out later on that the power of attorney didn't work, they needed the trust, and those types of things. So that's helpful to keep in mind when you see it come up. Have the documents ready to go from the client to be just to be efficient as possible. So I'm going to, let's see, I'm not seeing anything in the chat that really stands out as something that I want to go into. So this is a good kind of transition point. What I like to do is give an example because I'm saying all this stuff, but what does it mean? How does it apply? And so I'm always talking about Pat and Sam. There's an example case where we've got Pat and Sam. They are in their 60s. They like to snowbird to Arizona and they have $4 million in assets. So I've got somebody like this that comes to me and they're saying, do I need to have a trust? What should I do? We've got 3 adult children. They're in their 40s. Our son Mike is responsible. He's financially successful. He's married to his college sweetheart. He's given us 2 great grandkids. We've got our son Tom. We love him, but he's on his second marriage, and it's not going well. We know he's going to get a divorce again. He's got great income. He's paycheck to paycheck. We know that he is living on the edge. Then, of course, we've got Kathy. She was born with disabilities, and she's on government benefits for her disabilities. And they're coming to me saying, what can we do? How can we protect ourselves while we're alive? How can we give something to our children, but make sure that they're protected, especially Kathy and Tom, who have their own issues. So for them, I put together, I'm identifying, okay, so we've got out-of-state property because you snowboard in Arizona. You've got $4 million in assets. Washington's limit is 3 million, so you do exceed the limit. And you have 3 adult children that need protections. So Tom needs protections because he's riding the lightning here. Kathy, she's got disabilities. And then Mike, you would think he is good to go, but actually Mike has plenty of his own money. That one more dollar from his parents is going to cause him to have more money that he has to pay taxes when he passes away. So I'm looking at how do we protect all of the relevant parties here. And so here's a breakdown of how, and this is going to get all filled in with the assets, where they go and how they get allocated out. So we've got Pat and Sam over here. We create a trust for them, and this is for their accounts. So they've got pay on death, transfer on death, joint tenants with right of survivorship. You guys probably see this with houses, joint tenants with right of survivorship. and beneficiary designated accounts. Everything that Pat and Sam own is going to go through their will, which does have to go through the probate process. Everything owned by the trust is going to go based on what the trust says. Everything in this category is going to go based on how it's designated to go. We still are going to do a will, and it's going to be what we call a pour over will. And we're going to say, take everything Pat and Sam have, put it in their trust. The goal here is that they don't actually have anything in this category. We've already put it in their trust, or they've got pay on death designations for their accounts. So we've got their stuff in their vehicles. We're going to do an assignment. We're going to assign their stuff in their vehicles to the trust. The trust is actually going to own their primary residence in Washington, their Arizona house that they like to snowbird to. They're going to own, the trust will own that. So we're going to do a quitclaim deed, put those over there to the trust. And we're going to put a brokerage account in the trust. They want to make sure that there's actually money available immediately when they pass away. And that's where having that brokerage account is going to be helpful for some liquidity needs that they will have. And then everything that's going to land in these other accounts are going to be things like IRAs, 401ks, any annuities, life insurance, checking and savings. Those are going to be beneficiary designated. And just because they're beneficiary designated, it doesn't mean they don't go to the trust. They could name the trust as the beneficiary of this account, for example, or the trust could be the beneficiary of the life insurance. That would be just fine as a way to get those into the trust when they pass away. The trust is just not going to necessarily own these during their lifetime. The IRAs and the 401ks, those are special. There's tax benefits to those. So those are going to stay pay on death, usually to a person. So then, okay, now what happens when they pass away? So first it's going to be, so let me back up. The powers of attorney are going to be in charge of this. I just clicked back. Sorry about that. Powers of attorney are in charge of this and this. The trustee is in charge of this. Typically, they're going to name the same person, but it's a different document that controls depending on how that asset is particularly owned. So here's what happens when they pass away. Here's the breakdown. We've got the first spouse death. Remember, they've got joint assets of about $4 million. On the first spouse passes away, you get a step up on the applicable assets. And so typically you're looking at, you guys, you know about doing comparative market analysis, or you can do a formal appraisal to find out what is the current new basis in the real estate. Washington's estate tax limit is $3 million. There's 9 months to do this split off that I'm talking about. The IRS says you get 9 months to figure it out. So we're going to say, okay, well, half of it, or up to $2 million, is going to go into this split off trust over here. We call it either residuary, credit shelter, marital, bypass. All these are different types of trusts that we're going to allocate half of it over to say this is going to be allocated to the person who's passed away, that spouse. Then there's a survivor's trust that will keep the rest. We put $2 million in each side. And then remember that those accounts are going to stay in the name of the surviving person, and those are outside of the trust. Those are going to go based on that designation. And so it might be that the life insurance goes designated to the trust, but it's going to be based on that designation. Then when the second spouse does pass away, anything that was put over here is going to get another step up in their basis. And if it's over $3 million, if this category is over $3 million, then there's going to be another tax for Pat and Sam. But we're purposely going to split it up before we get there. So hopefully we can avoid any taxing at all for them. And then we're looking at, well, okay, now what happens when the second one passes away? What are we going to do for those 3 kids? So it's going to come back together. It's going to drop into the family trust. That's where it's all going. With the family trust, we then do 3 different trusts for the 3 different kids. Remember, they all have their own special needs. One of them, literally Kathy, she does have disabilities. She needs a special needs trust. So there will be a Mike trust, a Tom trust, and a Kathy trust. And then I'm going to break down what's going to happen for each of those trusts. So remember, Mike, he's the responsible one. He's got his two kids. He's married his college sweetheart. They're not worried about him getting divorced. For Mike, we create a sub trust. We say lifetime trust for Mike. His kids are a secondary beneficiary. This prevents the assets from becoming Mike's assets because we don't want Mike to have that much more money when he does ultimately pass away. We want to keep his estate down, but we still want him to have the joy and the benefit of his inheritance. For Tom, he is the one that's riding the lightning here. He is on his second marriage. He's probably going to get divorced. He's got great income, but he's for sure going to go bankrupt. So we're looking at, for Tom, we're going to name Mike as his trustee. And we're going to say that Tom's goes into a trust for his lifetime. And the point of that would be Tom's not in charge because Tom is going to frivolously spend the money while Mike is going to keep it protected. Also, if it's not Tom's money, then when he does get divorced and if he does go bankrupt, this inheritance that was put in this trust that Tom is not in charge of is not subject to either that divorce or that bankruptcy. For Kathy, she's the daughter that was born on disabilities. She born with disabilities. She's on government benefits for those disabilities. We're going to do a special needs trust for Kathy. We want to make sure that Kathy can benefit from the inheritance but doesn't actually receive it because if she does, she'll be kicked off of those government benefits. And then that will affect her ability to qualify for things. So then Mike will be in charge as trustee for his sister Kathy. If there's money left over in Kathy's trust, then Pat and Sam can direct to say, okay, we'll give it to my other two kids or do whatever they want to do with it. But it preserves the benefits for Kathy for her disability benefits. And so that's the three-way breakup there. We've got, it'll be trustee for Mike. He's trustee for all of them. Mike's the beneficiary of his trust. His kids are the backups. It's for the rest of his life. Tom, Mike's in charge. Tom's the beneficiary. Tom's kids can also get some help if needed. It's for Tom's life. Same thing. Mike is the trustee for Kathy. She's the beneficiary of her own trust. And then Mike and Tom's trust in this situation, the parents said, when Kathy passes, if there's money left over, then give it over to Mike and Tom's trust and just put it all together. That is what we did in this situation, or what I would do in a situation like this that has several moving parts. A lot of people were trying to protect here and a lot of different impacts that could happen with the different assets. Pitfalls of a trust are some people fail to fund the trust. And so that becomes an issue. We can put all this beautiful paperwork together, but if the trust doesn't actually own anything, then it doesn't control anything. Or they fail to establish that split off, that disclaimer, or that credit shelter trust. That's the split off I said that happens where we were able to split Pat and Sam's assets 50-50. You have 9 months to do that from when the first one passes away. If that doesn't happen, it's too late. We can't go back in time and do it. They fail to title future assets into the trust. That can become an issue if we put a trust together and then they go on and then they usually will, what we see happen is somebody downsizes their house, buys a different house and doesn't put it in the name of a trust. If they don't create a pour over will. So if something gets forgotten and they don't put it into the name of their trust or have a beneficiary on it, then a pour over will is going to catch that and put it into the trust. They don't think about contingencies. A lot of people imagine that life will never change from where they're at right now. The people that they choose to be their powers of attorney or their trustees would never pass away before them. And of course, that just doesn't happen. And so making sure that you've got backups. When I say choosing the wrong trustees, I'm talking about in this the example I just gave where we said, Mike is the one in charge. We're all assuming that Mike's a good, normal guy. If Mike is going to go on a power trip and destroy his family's life because he's got all the power now, we're not going to choose that guy, right? We're going to choose somebody who's going to respect everybody involved, not use the power to wield over their siblings or anything like that, and is going to follow what the rules are of the trust. The other thing is I gave a sort of complex trust example. If we've got 3 adult siblings that don't have any need to put it into a follow-up trust, I'm not going to do that. I'm not going to make an overly complicated trust just because. If there's no reason for it, then we'll make it as simple as possible. Other issues that come up is lack of communication. Usually it's the trustee. Family members feel like whoever's in charge is not being forthright, is not being honest with what's going on, and that creates a lot of drama. And then there's the tax consequences. Sometimes people, they don't consider the step up in basis, they don't consider the estate taxes. There's income tax differences. Those things have to all be considered. An example case where the trust funding went wrong. It's another example. Different person named Pat had kids or had no kids. Excuse me, had no kids, but adored her daughter's best friend. Created a revocable living trust, put her house in it, and said everything goes to my daughter's or my best friend's daughter. It was like a niece to her. Everything goes to my best friend's daughter. Many years later, Pat downsizes, buys a cute little house, and makes life a little more simpler. The realtor says, you know what, forget about the trust. That's more complicated. I don't want to deal with it. You don't want to deal with it. Let's just put the new house in your name and then call it good. What happens is Pat dies. Pat doesn't have a will. Nobody can find Pat's will because she's the trust would handle everything. And so now Pat owns the house. There's no will. And the trust is what said it goes to her friend's daughter. The trust had no control over the house because Pat didn't put the new house in the trust. What's happening is the house it's caught up in the courts. Right now, they're looking at just the distant relatives of who's going to get the house. So because Pat didn't have a will, the law assumes that she would want it to go to her favorite relatives, which she doesn't even know. So the law assumes give the house to the relatives because it's not actually owned by the trust. This is the type of thing where realtors can spot the issue and make sure if you're selling it out of a trust, make sure your client is knowing what they're doing. If they're buying a new house, should they put it back into the trust, or is there a reason not to put it back into the trust? When we create the trust, the process is we have a conversation, we do the drafting, and then we do the signing. Number 4 is to actually fund the trust. That's the piece that sometimes gets missed. Make sure the assets that you think are in the trust are actually in the trust. And I hit my goal. I was trying to be done by 12:45, and so I maybe have sped through this a little bit more than I needed to. But I wanted to go over any questions that anybody has. So I can start with the chat unless there's one that comes up, Shannon. We go from there. Oh, you're on mute. Thank you.
I said I've got a couple ones that came to me personally too, but we'll start with the chat here too. So if you've got a question and you want to be a little bit shy, that's totally fine. Throw it in the chat and I will ask it for you. Otherwise, go ahead and yeah, thanks, Welty. I see you. We'll get to you here in a second. So Jamie had a question. He says, I'm pretty sure that trusts can't get a conventional mortgage. Is the best strategy to buy the house as an individual and transfer title to the trust after closing? How would you
Yes.
structure that kind of situation?
That is exactly what that's exactly what I would recommend to do. So that's exactly what comes up regularly. Most people's trusts don't have a pot of money to just go buy a house, right? So the conventional mortgages typically are for humans, not for trusts. So there is, it's called Garn St. Germain. I'll type it in the chat here. I don't know if I'm going to spell it right, but there is, I'm going to look it up and actually type it in correctly. There's a law that protects the person. So they can do the mortgage in their own name, and then they can immediately transfer it into their revocable living trust. It happens as well when somebody goes to refinance a house. They're going to, often the lender will say, well, take that out of a trust. So if it's, assuming it's a revocable living trust, they'll take the house out of their trust, put it into their individual name, do their refinance, and then they go put it back into the trust after that. Okay, so I see the next one, Lynette. We are buying a house from our, maybe that says neighbor, who has the home in a trust, and this was his primary. We're paying off his one loan and assuming his other. We're buying the house for 600. It's worth 850. We're giving the house back the house to him when we die. Oh, well, you have to pay capital gains. Let me make sure I'm understanding this transaction. So
Oh, it's his nephew. I know Lynette's situation. This is
it
her
is nephew,
nephew.
not neighbor.
Yeah,
Okay.
yeah.
Oh, we're buying a house for our nephew who has the home in a trust, his primary. Um, I'm trying to figure out at what point the capital gain transaction would happen. So if you own the house or your trusts own the house when you die, you don't get, there's no capital gain tax at all. There's no taxable event I'm hearing. The taxable event could occur when you purchase it from him. That could be the taxable event for him, but he would have the primary residence exemption there. I'm not
Okay.
sure, maybe I need more information on that.
Yeah.
Okay.
And for Lynette, if you're looking for Andrea's information, I put it in the chat so you guys can screenshot it or copy paste, do what you need to do there as well. Welty, you had a question. I don't know if you want to unmute your line. Not sure
Yeah,
who
and it
Welty.
was actually asked in the chat, so it
Okay.
was answered.
No, it wasn't answered yet.
Okay, go ahead.
Okay.
Is there any reason, it's just replicating what somebody asked in the chat. Is
Yeah.
there any reason not to have a trust?
It cut out. Did you say, is there any reason not to have a trust?
Yes.
Yes, there's many reasons. So, a couple of reasons not to have a trust, and a big one is going to be in the Medicaid planning context. So, if you are looking at usually spouses, we're looking at one is going to end up needing long-term care and one, doesn't. There's different plannings we can do where we would not put the trust to be in existence now. We would have the trust come into being under your will. So you would want it to go through probate. Um, Other reasons would really just be for just complications. Some people find it too complicated to have a trust, but usually I'm seeing it there are reasons. I would want to know your specifics. So before I was able to I can't give you direct legal advice in this conversation.
Yeah.
But there's reasons not to. Yes.
Okay. Couple quick questions here, Andrea. So, because I know we have a lot of real estate agents that are on the call. So, when you have a trust, we get this all the time. Rochelle and I do as managing brokers. How do they sign? How does the seller sign?
Oh, the seller signs, yes. And so it's
Yeah.
buried deep in one of my, so it's this, if so we're talking the seller as a trust.
Yes.
So
Let's say
it
we've
would
got a
be
trust.
Pat as trustee of the Smith Family Trust dated July 17, 2026. So I'm going to put it in the chat. Pat Smith as trustee of the Smith Family Trust. Uh,
So the way that the paperwork would read on the purchase and sale, the seller would be the living trust name, and then the signer would be their first last name, comma, and then the jargon, right?
oh, I see. So
Yeah.
this is who the seller is. Pat Smith as trustee of the da 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 da. And then that's how they would sign. Pat Smith, comma, trustee.
Okay. Perfect.
Yep.
And then for another question we get all the time, so I told you we get it all the time, and people are sending them to me even now. Form 17, so seller disclosures in the state of Washington, are those required for trusts?
The last time I researched this, I don't know off the top of my head, the last time my memory of researching this is I believe yes, for a trust, it's no for a probate. So in the context of a probate, so to prior question, here's another reason. If you've got a questionable house, not that you're not disclosing things that you should, but that Form 17 is not required if there's a probate. So if it's being sold out of an estate and it's the personal representative, Form 17 is not required. However, I'm not aware of how you can get out of doing Form 17 if it's in the context of a trust as a seller.
Right. Okay. And that's what I remember you telling me too as well. It's the living trust. The people are still alive. They have
Yeah,
knowledge.
it's your house, you live there, you know where all
Yeah.
the stuff is.
Yeah.
Yeah.
And then a quick question too. So as a real estate agent, the moment the seller says that trigger word of, oh, I have a trust, what paperwork should we be asking them for? Like what should
Yeah.
if I'm a brand new agent,
Brand
what
new
should I
agent,
be
the
asking
first
for?
thing is you're going to pull up that last deed of record. You want to know, just because somebody has a trust, did they actually put this house in the trust? Is it owned? If so, I'm talking about a seller, right? So
Yes.
what does that last deed of record look like? Does it have the trust listed on there? If yes, then you're going to want the trust documents themselves. You're going to want it's either going to be you just said I want the trust. They should know what that means. If they don't, they're going to call their attorney. They're going to say, hey, my realtor's asking for this and I'm going to forward it to them.
Yeah.
And then sometimes they need a certification of trust, which can be created at some point along the way, but it's really going to be, is that last deed of record showing that it's actually owned by the trust? Then you're going to look to get them to give you a copy of the trust itself. The other thing that comes up is I've got people who say, well, I don't think it's in the trust because the green thing they get from the county doesn't show that it's in the trust, right? Or it does, but they don't think that it does. It says Pat Smith, comma TTEE, and they think, oh, that means it's not in the trust. Well, that comma TTEE is comma trustee. Or maybe they went to the county and they got confused about it, but the deed did not get changed. So that's where I would start.
Okay, perfect. And then Christine had a question. She goes, as an insurance agent, most companies don't let the trust be named as an insured. Is it okay for the individual named, I'm assuming as the trustee,
Mm-hmm.
list them as the additional insured? And does that change the asset protection piece of a trust?
That's exactly what I would recommend, Christine, is so it's usually people leave the individual, the trust, whoever's, the beneficiary, the trustor, or whatever, if they're primary residents, they leave them, it's their insurance policy, and then typically you're adding the trust as an additional insured. And I see that too in adding, if maybe they put it in an LLC, right? So maybe we're adding the LLC as an additional insured.
Yeah. Okay, perfect. Mary had a question too. So she goes, can you explain the benefits of a transfer on death deed and pitfalls for a transfer on death
Mhm.
deed for a real property, especially for those that are not interested in completing a trust right now, however, would like the assets to not have to go through probate.
Yeah, so the benefit of a transfer on death deed is you continue to own the asset while you're alive, meaning that when you do pass away, there is that step up in basis. It's yours. You can revoke it if you need to use the asset. If you want to sell the asset, it's still yours. None of this actual comes into effect until you've actually died. The downside of a transfer on death deed is there is zero opportunity for contingency planning. So if the person you have named passes away, um, that's it. You can't name a backup in a transfer on death deed. It goes to the person you've named, and if they've passed away, that designation fails, and then it gets picked up either by your will or it goes through the intestate process. It's still going through probate. So that's the downside, is if the beneficiary passes away. The other part of it is, and this is we're assuming that the beneficiary is good to go, right? So if we've got minors, if we've got kids with disabilities, if we've got any of those issues, we're not naming them as a beneficiary. So in the situation where we've got a perfectly well-to-do, competent is a better way to say it, a competent beneficiary, then transfer on death deeds can be a good tool, assuming that you're on it if that person happens to pass away.
Yeah. Another quick mention. So Kirk, good point. He is bringing up your example where the daughter or the best friend is trying to provide assets to the best friend's daughter when she dies. And yeah, I would be very concerned as that real estate agent giving legal advice.
Yeah.
Well, she should have been deferring to an attorney or a tax advisor in that situation because we are not attorneys nor tax advisors. So yes, nice, good call out on that, Eric. Jamie had another question um, for mortgages. So in a scenario where there's a transfer title after closing, would the transfer require lender approval? Who takes on the mortgage in that kind of scenario if the person who took out the mortgage dies?
Did I ruin my share, by the way?
What was that?
Is my screen still sharing normally?
No, no.
Okay. Okay, well, so what I'm going to do is I'm going to look up that law because I know it by sound. But I'm just going to make sure I spell it correctly. Okay, there it is. It's the Garn-St. Germain Act. I'm dropping it here in the chat.
Okay, perfect.
That's going to be the thing that gets you there. So this is the law that basically says, you guys can still see me, right? Did my screen just stop sharing?
No. Yeah, we don't see your screen.
Okay, perfect. So I don't know how to fix it. It just says thank you and it has my information. So the Garn-St. Germain Act is the law that says if you're going to put it into a revocable living trust, then it does not trigger the due on sale or the due on transfer. So the lender can't say, oh, you've sold it, you've moved it along. You have to refinance this, right? So it would just go, let's see. So what was the specific question? So is it who takes on the mortgage in that situation? Oh, it's still the person. So you're not going to get out of, they're going to make you personally liable for that mortgage. It's still going to be in your name. You're the borrower. They might, depending on how many assets are in the trust, they might go for it, but typically people don't have enough assets in their trust, or the trust doesn't generate enough income to actually be the borrower on a mortgage.
Okay, perfect. I think that answers that question. And we had a couple of these too. So thanks, Eric. They're wanting to. Oh, sorry.
I see it. Then it says, I mean, the person if the person on the mortgage dies, that's a different situation. In that situation, if the person has died, that law would still protect if a family member was the person who inherited the house. The law does protect in that context. But the person who inherits the house would take it subject to the mortgage and would become the borrower on that loan. But they cannot be forced to refinance it. Garn-St. Germain says, like, for example, if you've got somebody with a 2.5% interest and they die, and their kid inherits the house, they can't make the kid refinance at today's rates.
Okay, perfect. And then can you explain the step-up base, explain the step-up basis for those that are green here on the call?
Yeah.
What is it? How does it work? Just kind of nuts and bolts a little bit real quick.
Yeah, so really it's all about the capital gains, right? So you guys see it. I'm going to pretend that we're not using primary residence exemptions at all. So I'm just going to make it up. Let's say we've got a house. You buy the house for 100 grand, and now today the house is worth 500 grand. And so if you sold the house today, your capital gain is sell price, 500 grand, minus purchase price, 100 grand. So your gain is $400,000, right? So the capital gain tax is going to be on that $400,000 gain. For the step up in basis, what happens is, let's say you didn't sell it today, it said you died. And so then instead of your basis being what you purchased it for, which is $100,000, your basis then becomes the date of death value, which is $500,000. And so then let's say your sister inherits, right? And your sister turns around and she sells your house today for $500,000. When she sells it, it's $500,000 minus the new basis, which is $500,000. So it's sell price minus the new basis because there was a step up to today's date of death value. And then there's zero gain. It's sell price minus the basis of today's current market value. It's the same idea that applies to stocks, but it doesn't apply to IRAs or 401ks. It doesn't apply for those, but it does apply for other types of stocks. And we call it a step up in basis. It should be more properly called an adjustment in basis. We're all just banking on everything going up, up, up. But if you had a scenario where you bought the house for, 400 grand and now it's only worth 300 grand, you do lose. It's a bad scenario for you. But generally, it's purchase price is your basis. Unless somebody who's owning the house dies, then it gets stepped up to their date of death value is the new basis.
Perfect. Yeah, thank you. I remember one of my CPAs when he was explaining it to me, he's like, it's one of the few benefits they give to people when they pass away from the IRS. Yep. Yeah. Okay, so real quick, a couple last questions. We're just going to rapid fire. I want to be respectful of everybody's time, but another disclosure question: what happens in a estate of a home if the trustee, so it sounds like this is a trust situation, isn't aware of the problems with the property, doesn't disclose something they're unaware of? Oh, I can't speak to that, Andrea. That's on you.
I would say that's a Form 17 question. It's one thing to say, I'm not aware of something. It's another thing to say, I closed my eyes so I didn't see that the roof had a hole in it, right? It like depends. It always depends.
Yep. And then one last question from Christine. So thanks, Christine. Does it complicate claims? Let's say there's a fire and the trust is notified. Do they have to sign off or agree to the rebuilding process, assuming the kid is in charge on behalf of the parents still in the home?
That's a good question. So generally, in that context, so if there's a trust and the kid is acting as trustee, but the parents are still alive, generally the parents are still the beneficiaries. So the kid has the fiduciary duties to honor whatever's best for the parents because they are the beneficiaries of it. So that's my example of, a trustee coming in and saying, I don't really want to participate in this process. Well, then you're going to get removed, right? So because it's supposed to be for the benefit of the parents. It is best if they're participating in the process, it would make sense that they would participate. But if it looked like they were not agreeing to rebuild or anything like that because they were trying to, benefit themselves, then they need to be removed. Yeah.
Okay.
So
Perfect. Well,
the trust being added doesn't affect the claim at all. They just get notified.
Yeah, I would say it depends on who.
Like they don't get involved, right? Because the people are still alive at that point.
I wouldn't be able to speak to a specific situation. It sounds very specific.
Okay.
Unless I was really talking to the person and saw more in front of me. But as a general rule, it's the owner of the house is the trust, and then the insured parties are usually the trust is an additional insured. It's best if everybody's being cooperative, but if they're not, then usually that's when people get removed.
yeah.
I was just wondering how much trouble it causes to have a trust when it comes to insurance, because I know when a house burns down, you have to notify the mortgage and the mortgage controls the payout of the fire loss. And so I
the
didn't
mortgage is
know.
always going to get paid first. Yeah, that's for sure.
Right. But I didn't know if the trust adds an extra layer of problem for the customer, is I guess what I'm getting at.
I see what you're saying. Yeah, I mean, I wouldn't be able to speak to the generality of.
Do they have to be added? Does the trust have to be added at all?
So it's best if the trust is an owner of the property, it's best if they're added as an additional insured. That was an issue that happened a lot with like the Malibu fires. That was a lot of issues that came up. Is a lot of California has they're a trust state. A lot of people have trust in California, so that's an example where insurance companies were trying to get out of because it was owned by a trust. They weren't necessarily successful, but it was another hurdle.
Oh, got it. Okay. Great.
Quick answer there. Trustee can also be a beneficiary. Yes. So when people put a revocable living trust together, they usually act as their own beneficiary, their own trustee. Yep.
Yeah. And I think this, Anne had a great question. I think this kind of just is a great way to wrap us up here, where she goes, what can you help me create a trust? Like, when should I be doing a trust? When should I be calling Andrea here to set some stuff up for me?
Yeah, so then an LLC over it depends on the goals, right? It depends on what you're doing. Usually a lot of times when you're putting a property into an LLC, it's usually it's rentals that we're putting in an LLC. You would never want to put your primary residence into an LLC, and for a variety of reasons. So depending on the person's goals would affect whether we're putting in an LLC or a trust. And typically what we find we end up doing is we're doing both. We'll create a trust that owns the LLC that owns the rental.
Right. So if we've got a client, like when should we kind of friendly suggest they call you, Andrea?
Yeah, I mean, if you that's a great question. So if you've got somebody who's thinking about, I've got a rental, I've got all these properties, or I think I should put a trust together, I'm not really sure what to do. Then you can have them call in. What the process is, my assistant will take their information. She'll do a conflict check, because we do have other attorneys here, and we never want to deal with somebody that we're actually suing. So we do a conflict check, make sure we're not actively suing the person. And then they would come in for a consultation and I would sit down and talk with them about it. And depending on what their situation is, then I would put together whatever they needed. It would be, my consultation is $400. And then whatever we end up doing, I wrap up that into the flat fee. We typically do flat fee for LLC creation or trust creation or whatever we're doing. That just gets rolled into it.
Perfect. Awesome. Well, thank you so much And I know you guys have a lot of questions that are probably going to continue to come in. So I would say you've got Andrea's information. You're welcome to reach out to her directly, especially if you've got something super, super specific. But I just want to extend my gratitude. It's always fun when we can get an attorney on a call. You guys are hard to catch sometimes for these types of things. And Andrea's always been very willing to lead with education. I think that's one thing that makes her, it sets her apart from other types of attorneys. So thanks so much for joining us, you guys. Hopefully you guys can have a great weekend. And if you're looking for Andrea's information, just let her know or send me a message. I'm happy to send it over to you guys as well.
Thank you, Shannon. I do a newsletter, so if you have anyone to sign up for that, you could go to my website, sign up for it. I try to do regular seminars, so they're on my website if you ever want to find one. Have a great summer.
Perfect.
Bye,
Thanks,
everybody.
you guys.